Hi, Attorney Rob Wells here from the Law Office of Robert Wells, and in this video we're going to cover the statewide price gouging statute contained in Penal Code 396 and how it applies to landlords and rental increases during a state of emergency. So, this video is going to cover the Penal 396 provisions, and we're particularly going to focus on the provisions related to housing. For all those that don't know what Penal Code 396 is, and believe me, we've harped on this issue since 2017 when this became a major issue with the fires that broke out in 2017 in Napa and Solano and Sonoma counties and so forth. This obscure penal code section never really came into effect until that period of time on a statewide scale. It is a criminal statute that prevents people from increasing prices of consumer goods and services during a state of emergency. It was really, again, like I said, an obscure statute, and it was pretty much beefed up last year, and it was the beefed up provisions came into effect January 1st of 2019. So we'll go over those right now. Penal Code 396 prevents individuals and organizations from, again, capitalizing on the misfortunes of a state of emergency by raising the prices of essential consumer goods, including rental housing. The law generally limits the maximum rental increase to which a landlord can raise rent to 10% when a state of emergency is declared. The prior Penal Code 396 before 2019 really only affected rental units offered for rent or currently rented. This new Penal Code 396 section expands the protections to housing units not on the market at the time of the state of emergency is in effect, and also eviction protections are now incorporated into Penal Code 396 to prevent eviction of tenants for the sole purpose of operating units to new tenants at higher prices than permitted under the statute, so to speak. And let's step back here. When can a state of emergency be declared, and who can declare a state of emergency? Well, it's quite simple. Either the federal government, through like the President of the United States, can declare a state of emergency. The most common types of declarations from the state for a state of emergency are either going to come from the office of the governor of the state of California, or either a local municipality, such as the county's board of supervisors, or a municipality can declare a state of emergency. And a state of emergency means what it really is, what it states. It's pretty much a, like a natural disaster, such as these firestorms, these wonderful PG&E blackouts that have been plaguing the state, earthquake, riot, diseases, natural disasters, acts of God, pretty much are going to be qualify as state of emergency type events. So, how is price determined under the unrented unit at the time type deal? There are a couple of things that happen, during a state of emergency. So let's go over kind of the common scenarios. The first scenario would be, hey, you have an existing landlord-tenant relationship with your tenant. Let's say the rent is $1,000. Well, guess what? It's very simple to determine what the landlord can increase the rent to. In our $1,000 a month case, the landlord could raise the rent no more than 10% or $100. So he or she can raise the rent no more than to $1,100. Now, things under the old code section got complicated because the code section never addressed issues where what happens if a unit is vacant, or what happens if a unit was never rented or introduced into the rental market. let's say you have your primary residence, and guess what? You're going to turn that into a rental because you want to leave California and get out of this crazy state. Well, that unit's never been on the market. Now this new Penal Code 396 section covers those contingencies. So how is price determined for an unrented unit at the time of the emergency? Well, the code section says this. If the unit was rented within 1 year prior to the state of emergency, the most recent rent within the year before the state of emergency is going to apply. In our case, for a lot of cases with my owners, the ones that got punished the most were the landlords that were undercharging rent. Their rents were way under market. Let's say they were renting a property for $500. Well, under this new definition of what the landlord can raise the rent to, rent can't go no more than $50 in our $500 a month case. So a landlord that was thinking that they were doing a good deed for their tenant by never raising the rent kind of gets punished in the sense of, well, now if they ever needed to raise the rent, let's say they needed to sell their house or something like that to get the rents up so they can sell their rental property to another investor, it's not going to be as desirable to a new buyer because their rents are underwater, so to speak. Now, for units that are not rented within 1 year prior to the state of emergency, the code says that the landlord can raise the rent 160% of the fair market rent established by the U.S. Department of Housing and Urban Development. You go on to the site of HUD's website and you basically put in your zip code for your where the house is located at, and you will find a chart of housing based from studios. I believe they go up to 3 to 4 bedrooms, and the HUD will publish a number for your county or zip code, and that's what you can raise the rent to. You can go up to 160% of the fair market rate established by HUD. Okay. So again, for units that were rented or advertised for rent, we covered this in the last slide here. You could raise you have to use the lowest rate of rent to calculate your 10% price increase. So if you advertise the property for $500, or you're renting the property for $500 within the last year prior to the state of emergency, you can only go 10% from that rate. Landlords who rent unfurnished units that are now furnished, you can increase it 5% more. So, however, the new state of emergency code section now covers, they made a provision in there saying that there's no adjustment allowed for any of the prior rent charged for any other good or service, including but not limited to gardening or utilities currently or formerly provided in connection with the lease. In English, that basically means that no, you cannot add additional charges for utilities and gardening and other amenities connected to the lease to get over that 10% rate. You're kind of stuck at 10% of the base rent, and you can't do anything to increase that otherwise. And then again, if your unit was not rented within that prior year, you get 160% of the market rate established by HUD, and you can increase that by 5% if the unit's fully furnished. So, big question is, how long do the Penal 396 code regulations or restrictions last? Generally, it is the length of the time that the state of emergency is declared by the proclamation, plus any extensions made by the governor or entity issuing the state of emergency. To give you some perspective on this, back in 2017, when Governor Jerry Brown was in office, he would declare state of emergencies for up to 6 months, and then he would extend them again, due to the wildfires and so forth. The new code section adds whatever the length of the proclamation is, plus 30 days after the state of emergency expires. So you have that to contend with. And in our most recent state of emergencies for the PG&E power crisis and so forth when the Governor Newsom declared the state of emergency for the entire state. He put no dates on there. So basically, if we read the 396 provisions, it's 30 days from when the governor made the proclamation of a state of emergency here. Okay. So, are there any exceptions? There are some exceptions from Penal Code 396 for repairs beyond normal maintenance or for increases issued before the state of emergency. So rental increases that were over 10%, and if you're not subject to the new AB 1482 regulations we've been talking about, yeah, you can have an increase that goes above 10%. If you raise the rent over 10% during a state of emergency, you must show that you have to prove that the increase is directly attributable to additional costs for repairs or additions beyond normal maintenance that were amortized over the rental period that caused the rent to be increased greater than 10%, or the increase was contractually agreed for before the proclamation. So, again, you better have proof that these are costs beyond normal wear and tear that are attributable to the state of emergency. Let's say, hey, look, the cost of supplies was increasing due to a shortage of materials and so forth out of, the landlord's control. You're probably going to be okay as long as you can prove that the increases are justifiable by additional costs and so forth. Okay, so penalties for violating this penal code section. Okay, you got to remember this penal code section, which is a criminal statute, so you could face fines of up to $10,000 and/or 1 year in jail, because this is a misdemeanor under California law. You also face civil penalties under the California Unfair Business Practices Act under Business and Professions Code 17200. The practical issues that we face with these states of emergency, however, that aren't listed are if you ever have to do an eviction for non-payment of rent and you increase the rent more than what's legally allowed, you're going to have issues with your eviction case, because under the law in California, if you demand more rent than what is legally due under the law, your eviction's no good. And if you don't reflect those changes, you don't get your tenants credit back. You may have the problems with your eviction. You may get sued in court for the overages that a tenant has paid that are unlawful. So it's a pretty big deal if you increase the rent more than 10% during a state of emergency. If you were impacted by a state of emergency, it could have ramifications way beyond the state of emergency is over. So if you have a situation like this, you may want to reach out and figure out how to get a rental credits back to your tenants and so forth, because that's kind of where the trouble begins, is when people come to our office and we ask, hey, if you had an increase in rent and so forth, and landlords do, but then the landlords don't really know that Penal Code 396 is out there, so to speak. There is legislation being talked about or in the works about having a centralized database that the state maintains, where you can type in if your address is affected by a state of emergency yet, but that legislation's still in the works, and there's still, after the legislation's passed, they got to build the database as well too. So if that happens, we'll provide and give you links and resources and so forth for that, because that would be a helpful resource. Historically and currently, it is still kind of hard finding out whether or not a local city or county or the governor's office has declared a state of emergency for a particular county or area. So it is understandable that owners run into these issues all the time. So if you have any questions, you can reach out, and thank you again for listening to this presentation.